What happens when people walk into a courtroom thinking the rules don't apply to them? In today's intense courtroom drama, two separate hearings turn into unforgettable moments as judges are pushed to their limits, but never lose control. In the first case, chaos starts almost immediately. A man attempts to represent someone else in a criminal case, claiming strange legal authority and even denying his own name. He throws around confusing legal phrases, hoping to outsmart the system. But the judge isn't buying it. Calm, focused, and completely unshaken, he makes one thing crystal clear: in a criminal courtroom, only a licensed attorney can represent a defendant. No word games. No loopholes. No legal magic. As the excuses pile up, the judge firmly explains that none of this so-called legal strategy has any effect on the case. The courtroom tension builds as he shuts down every argument and sets a new trial date, warning them about the serious consequences of failing to appear again. Then comes the second case, and it's just as dramatic. A woman stands before the court with 9 outstanding warrants and a history of ignoring orders. Community service unfinished. Fines unpaid. Deadlines missed. She claims she couldn't comply due to personal circumstances, but the judge carefully points out inconsistencies in her story and a long record of noncompliance. You can feel the weight of accountability hanging in the air. But here's where it gets powerful. Instead of simply throwing the book at her, the judge balances firmness with fairness. He makes it clear that responsibility matters, but he's not there to destroy her life. He sets a structured payment plan, giving her one more opportunity to get back on track. These two cases show one undeniable truth: in a courtroom, confidence doesn't beat the law, accountability does.
5-8 State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, right. His authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here. All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear in this court for the plea day on his case, which was set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an article 3 trial?
To what?
Will that be an article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
All right. She pled guilty to failure to pay fines and costs as ordered and failure to provide proof of completing 24 hours of community service by October 1. I told her on October 1 that I was going to set it over for sentence. or on November the 21st, adjourned it to December 19th. I got a call from my judicial clerk saying that she was sick or her child was sick or something along those lines. I adjourned it over to today. Is there anything you'd like to say? Tell me, give me proof that she's done her community service.
Your Honor, she does not have proof at this time.
Why not?
Judge,
She
currently.
didn't do it.
Yes, Judge. I note that she is currently on bed rest. She's 6 months pregnant. When I discussed the outstanding balance, she's respectfully requesting consideration for a payment plan. She can make a $100 payment this Friday, and then she'd be asking to make.
Why would I give her a payment plan when I know I told her on?
The courtroom is quiet, but the tension is immediate. You can feel it in the air before a single word is even spoken. This isn't just another routine hearing. This is one of those days where the judge knows patience is about to be tested. The first case begins with confusion almost instantly. A man steps forward attempting to represent a criminal defendant. Not as a licensed attorney. Not as appointed counsel, but as someone claiming special authority through unusual legal theories. He speaks confidently, almost rehearsed, throwing out phrases that sound official but quickly fall apart under scrutiny. Then comes the moment that shifts the atmosphere entirely. He refuses to acknowledge his own legal name. The judge pauses, calm, measured. He asks simple, direct questions. Are you a licensed attorney? Do you have the authority to represent this defendant? The answers circle around the question but never land on solid ground. The man continues insisting he has the right to act on behalf of the accused, suggesting the court lacks proper jurisdiction and implying that traditional legal rules don't apply to him. But the judge doesn't raise his voice. He doesn't argue emotionally. Instead, he explains clearly and firmly that criminal representation is not optional, not symbolic, and not based on personal belief systems. In a criminal court, only a licensed attorney can represent a defendant. Period. The law is not flexible on that point. The individual continues to push. He references obscure legal concepts. He claims special status. He insists the court is misunderstanding him. The judge listens, allowing him enough space to speak so that the record is clear. Then he methodically dismantles the argument. He explains that none of the statements made have any legal effect on the criminal proceeding. Words alone do not override statutes. Personal theories do not invalidate established law. The defendant, Matthew Neil Aldridge, stands at the center of it all while the back and forth unfolds. The judge makes it clear that the case will proceed according to standard criminal procedure. No shortcuts. No imaginary loopholes. If the defendant wants representation, it must be through proper legal channels. If he chooses to represent himself, that comes with strict rules and consequences. There's a moment where frustration begins to surface from the man attempting to intervene. He insists the court is ignoring his filings. He suggests constitutional violations. But the judge calmly clarifies that filing documents filled with nonsensical legal jargon does not automatically create valid legal arguments. The courtroom isn't a place for theatrical performances or philosophical debates about sovereignty. It's a place governed by statutes, precedent, and enforceable rules. As the exchange continues, the judge emphasizes responsibility. Court dates are not suggestions. Appearances are not optional. Failing to comply carries real consequences, warrants, additional charges, potential custody. The judge sets a new trial date and makes sure everyone in the room understands the seriousness of the situation. There's no dramatic outburst, just steady authority. What stands out most is the contrast between emotional resistance and institutional calm. The judge doesn't need to overpower anyone. The power comes from clarity, from structure, from knowing exactly where the law stands. Then the second case begins, and the tone shifts, but the intensity remains. A woman stands before the court facing 9 outstanding warrants. 9. Each one representing a missed obligation, an ignored directive, a failure to follow through. The list includes unpaid fines and incomplete community service. The judge begins by reviewing the history, and it quickly becomes apparent that this isn't a single oversight. It's a pattern. She explains that she couldn't complete her community service because of personal circumstances. She mentions being pregnant. She implies hardship. The judge listens carefully, flipping through the record. Dates are reviewed. Previous extensions are noted. Prior warnings are read into the record. There's a subtle but important shift here. The judge isn't dismissing her struggles outright. Instead, he's comparing her claims against documented timelines. If she was unable to complete service during one period, what about the months before that? If payment was impossible at one time, what about the extensions previously granted? Inconsistencies begin to surface. The judge calmly points them out. Not aggressively, not sarcastically, just factually. The courtroom grows quieter as the weight of the history becomes undeniable. 9 warrants don't appear overnight. They accumulate when obligations are repeatedly ignored. The woman becomes emotional, explaining her difficulties. And this is where the moment becomes more layered. The judge acknowledges that life can be difficult. Circumstances can be overwhelming. But accountability doesn't disappear because life is hard. Court orders are not optional guidelines, they are enforceable requirements. Still, instead of immediately ordering severe punishment, the judge shifts toward structured accountability. He explains that he is not trying to bury her. He is not interested in creating impossible burdens. What he wants is compliance, follow through, effort. He outlines a payment plan, a realistic structure, something achievable if taken seriously. But he makes it crystal clear that this is not another open-ended opportunity. This is a final chance to correct the pattern. The difference between the two cases becomes clear. In the first, the battle is ideological, an attempt to challenge the legitimacy of the system itself. In the second, the struggle is practical, repeated failure to meet obligations. Yet in both, the judge responds the same way, firm, composed, grounded in law. There's no shouting, no dramatic theatrics from the bench. Just steady reminders that courts function on structure, rules, deadlines, consequences. The sovereign-style arguments collapse because they rely on belief rather than enforceable authority. The repeated non-compliance case moves toward resolution because the judge combines firmness with measured compassion. As the hearings conclude, one message echoes louder than any individual statement made that day: the courtroom is not a place where confidence overrides responsibility. It is a place where accountability is unavoidable. In the first case, the attempt to bypass the system fails because the system is built on established law, not personal declarations. In the second, leniency is offered, but only within the framework of structured responsibility. These moments highlight something deeper about the justice system. Judges are not there to debate philosophical interpretations of freedom. They are there to apply the law. And when people test those boundaries, whether through legal wordplay or repeated neglect, the response is not chaos. It is clarity. The sovereign claims fade under scrutiny. The excuses weaken under documentation. What remains is the steady voice of authority explaining, once again, that accountability cannot be talked away. By the end of these hearings, the energy in the courtroom feels different. Not explosive, not dramatic, just settled. The lines have been drawn clearly. Appear on your court date. Follow lawful procedures. Complete what you are ordered to complete. Pay what you are required to pay. Or face the consequences. And that's the quiet power on display here. Not anger. Not humiliation. Just the unshakable reminder that the law does not bend to personal narratives, but it will offer structure to those willing to take responsibility. Two very different defendants, two very different strategies, one consistent outcome. In a courtroom, reality always wins.
Have the money. Why would I now be sympathetic over somebody saying they're 6 months pregnant when I ordered this in July? She knew when she got pregnant. I gave her till October 1. That would have been 3 months earlier. There's no reason she couldn't have done a sedentary job in either July, August, September, October. And she told us, I think she did community service, but she's not going to do community service because she doesn't think she needs to do community service. Did she do her court work program?
Yes, Your Honor, and she was doing court work program all the way up into September, so I'm not sure when this bed rest claim has come in.
She was doing what?
She was doing court work program all the way through the middle of September, so I'm not sure where the bed rest comes in.
She's just, listen, sometimes I don't feel like calling them. It's the day before Christmas. She's not kidding me. I mean, this is nonsense. Did you go to the doctor about the COVID the other day?
I didn't have COVID. My daughter had the flu and had
Your daughter had the flu.
And I have proof of that, yes.
Well, let me see it. Did you go to a doctor?
Did I go to a doctor?
Did she go to a doctor?
Yes, she was in a hospital.
Okay, I don't need the proof. What do you want? What else is she doing? Is she doing our outpatient?
Yes, Your Honor, to her credit, she is compliant with her outpatient treatment. Really, at this point, she owes the victim's impact panel, and she still has not cleared several of those warrants that she has outstanding.
You haven't gone over and done that either, huh?
But she indicated that she took care of her warrants out of Wayne and Westland.
Let's see here. I don't have that handy. Where else does she have warrants out of?
I ran her record December 17th. She still had warrants out of Wayne, Westland, Romulus, Taylor, Westland, Romulus, and that is all, Your Honor. So she still had warrants out of those jurisdictions as of the December 17th date.
Did you go over to Taylor?
I never knew I had a warrant for Taylor.
Did you go over to Romulus?
I never even got pulled over by him.
Did you go over to Romulus?
No.
She's not lying to you. I mean, they're on there.
That's fine, but I don't know nothing about any of that. Taylor or Romulus, I've been
Because you got in a
aware.
bad habit of thinking you're larger than courts. That's what happened.
That's not what it is.
Okay, how many total warrants did she have on there?
Your Honor, 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 total warrants.
Let's not act like you can't wait to go to court when you get a ticket, okay? Let's please save it. I don't want to hear it.
If I knew, I would say that. I'm a grown woman.
Well, they're
I do
not
know
lying.
nothing
People
about
don't put-
any of that.
People don't put warrants into liens, ma'am, unless you have a warrant in the jurisdiction,
Okay,
okay? When is your due date?
in May,
May?
yes.
I thought you just said she was 6 months
I'll
pregnant.
be 6 months next week.
Well, that would make it March, wouldn't it, or not, or
No,
early April?
it's May.
So you're not 6 months pregnant.
I'm 5 months pregnant.
11 months if you said May.
No, okay. I have whatever.
Are you working? How are you supporting
No,
yourself?
I'm not. I'm waiting on cash assistance.
Is the father helping you out of the child?
No,
Are you having complications with your pregnancy?
that's what we're trying to see. I have to go back.
Here's what I'm doing. Here's what I'm doing. You don't, but no doctors told you that yet, right?
No doctors told me what.
That you're having complications that are going to stop you from doing things, physical things.
Well,
Community service is very sedentary work. We can find sedentary work.
Yeah, they tell me the Victory Gym.
Okay. Well, you're going to do 2 extra days of community service, and it's all going to be completed by February the 7th. I don't like you not paying your fines. You told me you were going to pay weekly $50 in August. You didn't. You haven't.
I didn't tell you guys that. You guys made that up yourself. I never said that I was paying 50 weekly. What
does the pre-sentence report indicate her income was, Ms. Wilds, back when I sentenced? You have that in front of you. I don't need to see it.
Yep, she indicated that she was currently employed, that she was actually in training at Rocket Mortgage to obtain her state licensing, and she was also collecting $300 per month in bridge card food stamps.
For Diamond G, for me, I've never attended Rocket Mortgage. In a food stamp card, I get $535, not $300. That's not me.
Did I tell you to come and talk to me if you didn't have the money?
Yes. And
why didn't you do that? No. I would have told you that at the time of the sentence. Why didn't you do that? You paid nothing in 5 months, and now you're coming in and asking for time to pay, and I just don't appreciate it. I'm going to be reasonable with you under these circumstances, but I don't think you're really getting the fact that you need to comply with court orders. We don't acquire 9 warrants unless we think that we're bigger than courts.
And can I have that as well?
Ma'am, I'm not done talking yet. So let's quit acting like we're oppressed and start to understand that we have to show up and pay for our sins. And that's what we do. Now, how much did you say you can pay?
She can make a $100 payment this upcoming Friday.
And then how much can she pay?
100 per month with minimum on or about.
You pay $100 by December the 27th. And the 27th of every month thereafter. With all money due by, because I have to have it done before the end of probation, by August the 15th of 25. You don't have the money, all you have to do is call the court. We'll go on Zoom. I'll be happy to work with you, but you cannot ignore courts like this, ma'am. Okay, so you have to do all your community service by that date that I gave you. So you already owed us 24 hours. Now you owe us 40 hours, and that has to be done by February the 7th. If you get a note from a doctor saying it's an impossible task for you to do that, based on the type of work that you can do that's sedentary, I'll be glad to give you an extension. Okay? I wish you well. Stop being so angry. Go take care of the courts. Go surrender yourself on the warrants.
Can I have a printout of that? Just like
I can't give you a printout of the lien. We can tell you where, but they're all in Westland, Wayne, Romulus, and Taylor, right,
That's correct. That's correct.
I just want to make sure it's actually me.
Well, they wouldn't put
a job.
They wouldn't put those on there if they weren't you, ma'am.
A job in the
Thank you, Judge.
I never even said.
All right, you can go tell the judge that. All right.